cities. And I'd like to welcome you to our presentation today on the clean water regulatory challenges facing greater Minnesota cities. After I give a brief presentation, one of our environmental attorneys will walk you through a PowerPoint presentation which has tons of great information. Now, as you know, clean water issues are a hot topic in Minnesota. Governor Dayton has made clean water one of his signature agenda items, declaring this a, quote, year of water action, end quote, in Minnesota. And to his credit, the governor put money where his mouth is and put a large amount of money for wastewater treatment in his bonding bill this year. The CGMC supports clean water efforts, but we want to ensure that our cities have a voice in the regulations imposed on them and how those regulations are paid for. Now, through the years, through persistent advocacy, actually since 1995, the coalition has had an environmental program and made a significant impact on clean water policy. As a result of our efforts in the 90s and early 2000s, the Minnesota Pollution Control Agency changed some proposed regulations that needlessly and unfairly targeted cities. And the governor and legislature back then agreed to beneficial changes in the process to fund necessary wastewater infrastructure. On the whole, these changes we advocated for saved cities and the state hundreds of millions of dollars. Now, for several years after our early successes, the MPCA was less aggressive towards cities, and the CGMC environmental agenda took a back seat to other CGMC priorities like local government aid and economic development. However, I think that is over now, and in recent years, the MPC has again started to target Minnesota cities with expensive regulations that are often scientifically flawed and fail to achieve measurable benefits to water quality. We refer to this trend of increasingly restrictive and expensive regulations as the regulatory tsunami, which Daniel Marks will talk about in greater detail. It will cost cities billions of dollars to upgrade their wastewater plants and meet new regulations that are actually needed to protect water quality, and we understand that. But that's why it's so extremely important that we do not spend additional billions of dollars on other unnecessary regulations that are not based on sound science and do not improve water quality. This would be a huge detriment to prosperity in greater Minnesota. The goal of this presentation is to inform you about current and imminent regulations, the regulatory tsunami that affects cities, and to present you with a proactive approach to address the significant regulatory challenges in a manner that defends the interests of greater Minnesota cities and your ratepayers, while at the same time protecting Minnesota's water resources. It's not enough to complain. We have to offer solutions and be effective at our program. Today's presentation will be led by one of our environmental attorneys, Daniel Marks. So I'm now going to turn it over to him.
Good afternoon, everybody. My name is Daniel Marks, and I'm an environmental attorney with the law firm of Flaherty & Hood, and I do a lot of the environmental, legal, and regulatory work on behalf of the Coalition of Greater Minnesota Cities, and also the Minnesota Environmental Science and Economic Review Board. And as Tim said, today we are going to talk about the environmental regulatory challenges facing cities. And at this point, I'm going to go ahead and jump into the PowerPoint presentation that we have prepared for today. The first matter that I'm going to talk about is, I just kind of want to set the roadmap for today's seminar and tell you what we're going to talk about. First item on the agenda is we're going to really break down the problem that greater Minnesota cities are facing, this regulatory tsunami that Tim spoke about, overreaching and scientifically flawed and expensive regulations. And and the trend that we have seen where these regulations are failing in many cases to benefit water quality. And then we're going to spend a significant amount of time talking about the solution to this problem. And the solution is really a long-term and comprehensive legislative and legal strategy that cities should undertake that not only benefits cities, but also the environment. And we're going to talk in greater detail, but this solution that we're talking about involves both an individual component and efforts that individual cities can take on their individual wastewater permits, but also a collective solution component where cities come together to further these legislative and legal strategies on a collective basis. And it's important to make clear that both the individual city approach and the collective approach, they're both essential, and they need to work together simultaneously for cities really to be able to push back against what we really think is a broken regulatory framework. And then finally, we're going to talk a little bit about the CGMC's Environmental Action Fund and the vision for the future and how the CGMC proposes to implement the solution that we're talking about. Before I get going too far here, I just want to stop and let you know that if you have questions during this webinar, we do intend for this to be interactive at the end, and we're going to reserve some time for questions. So if you have questions, please email them to cgmc_communications@flahertyandhood.com. We will try to get to your questions at the end of the presentation. If we don't get to all of your questions, we will follow up with you directly or via email afterward. Okay, so what is the problem? And Tim talked about this regulatory, and before we get into this too much, I just want to make a few brief kind of qualifying statements, and that is that this regulatory tsunami, the regulations that we're talking about, the CGMC is not against all water quality regulations. We are in favor of those regulations, and we understand that cities have an important role to play in cleaning and protecting Minnesota's waters. What we're talking about today is when those regulations become overreaching, when they're scientifically flawed, and when they don't benefit water quality. And as you look at this list before you, this regulatory tsunami, this is a list of a couple of current, but also many imminent regulations that we're going to be facing cities. And each of these different standards that is on this list, the individual implementation of each standard will cost cities hundreds of millions of dollars to implement. The collective impact of all of these standards combined, we're talking about billions of dollars. And unfortunately, the analysis of the cumulative impact of these standards really has not been done by the MPCA or anyone else. And this is part of the challenge and part of the problem in this regulatory framework. So the overview today when we're talking about the problem is we're really going to talk about this broken regulatory framework and how it's broken and how it got there. We're going to talk about the costs imposed on greater Minnesota cities and ratepayers. And we're going to talk about some of the observations that we have seen recently where some of these standards, not all of them, but some of them are scientifically flawed. And we've also observed an illegal and an unreasonable implementation of these standards. And we've observed instances where the agency is imposing standards where science demonstrates that there really isn't a benefit to water quality. So to start off about the problem, I want to talk kind of a little regulatory context. Many of you are familiar with this, so just bear with me. But the regulatory framework that we're dealing with here really is the Federal Clean Water Act, which was passed in 1972. And the Clean Water Act makes it unlawful to discharge any pollutant from a point source, which primarily are wastewater treatment facilities and some industrial facilities, into the surface waters of the United States. And this Clean Water Act, the agency, the Minnesota Pollution Control Agency, now has authority to implement this Clean Water Act and develop water pollution standards that impact the state of Minnesota. And an important critique of the Clean Water Act is that during its development and ultimately when it was passed in 1972, there was a lot of powerful interests from commercial interests, agriculture, and a lot of politics and lobbying that went into play that carved out a fairly significant exemption of most non-point source pollution. And so really the Clean Water Act is focused on wastewater treatment. And primarily, unfortunately, in some cases, cities. Now, the framework that is developed out of the Clean Water Act is there is a 5-year wastewater permit cycle where cities get new permits every 5 years. And water quality standards, the regulations that apply to those permits, get updated every 3 years through what's called the triennial review. And often there are being standards developed outside of that context. And what has happened is that the evolution of these standards and the continuing updating of these standards has created a shifting regulatory playing field where cities can be forced to invest millions of dollars in one 5-year permit cycle, and then 5 years later can be hit with another and potentially expensive requirement or limit which requires an upgrade. And there's many instances of this happening in greater Minnesota. And then another trend which is concerning is that the water policy and the standards development is often an inside game that is shaped too much by politics and commercial interests in the radical environmental groups, and not sound science and what is actually demonstrated to be effective at cleaning water. And then part of this framework that we'll talk about as well, which is problematic, is that cities have become targets for regulation under this framework, partially because the commercial interests and the radical environmental groups have kind of shaped and pushed back in a way that really gets the agency, it becomes easiest for the agency to regulate cities for pollution reductions. Now, over the last 30 years, as a result of the implementation of the Clean Water Act, municipal wastewater has made significant efforts and had tremendous success at reducing pollution in the state of Minnesota. And nobody disputes the fact that greater Minnesota cities have done more and paid more to clean Minnesota's waters than anybody else in this last 30 years. We've invested billions of dollars in that effort, and it's something to be proud of. But we have now reached what we term the problem of diminishing returns, where pollution has been reduced to such an extent over the last 30 years, and we are reaching limits in what the treatment technology can do, that in order to make further reductions, in many cases, the cost to make those reductions is often disproportionate compared to the actual benefits to water quality. And so this problem of diminishing returns, which exists everywhere throughout the country as the Clean Water Act gets implemented, is also having a significant and a disproportionate impact on greater Minnesota, and we'll talk about that. Now, the costs involved, as we talked about briefly, are multi-billions of dollars for greater Minnesota. And these are capital costs, operation and maintenance costs, debt services, rate increases. And I think one of the costs that often does not get talked about or thought about is the opportunity costs. And by that I mean that when a city gets a wastewater permit, the conditions and the limits in that permit often govern future economic development capacity, population growth capacity, social development capacity, and those permits often impose these opportunity costs out into the future that don't necessarily get incorporated into what this actually costs the city. And the evidence demonstrates that the costs of these water regulations has a disproportionate impact in greater Minnesota. Not only does greater Minnesota pay more dollar per dollar comparison, but that amount is felt and it hurts more in greater Minnesota as a result of the disparities in median household incomes compared to the metro area. The MPCA estimates that the current projects that are scheduled based upon current regulations, not these regulations that we're talking about necessarily in this regulatory tsunami, but current regulations in place, is $2.2 billion in greater Minnesota alone. It's a significant amount of money, and frankly, we believe that that is an underestimate. Now, the other trend that is a part of this problem that we have seen in some instances is that these standards, some of the standards have been scientifically flawed and ineffective. And the example that I'm going to talk a little bit about now is the river eutrophication standards, or the water quality standards for rivers and streams, phosphorus standards for rivers and streams. And this is the water quality standards, the river standards that the CGMC and MESRB have been actively opposing in certain respects over the last couple of years. And one point that I think a lot of people aren't aware of is that prior to the adoption of these river eutrophication standards, there had already been significant phosphorus reductions made by cities. The MPCA acknowledges that from the wastewater treatment has already, prior to the adoption of these standards, reduced point source phosphorus pollution, so the phosphorus pollution that's coming from cities, by more than 70%. So these river eutrophication standards are really targeting 30% of what the cities contribute to phosphorus pollution. So it's a fairly low percentage of the actual overall phosphorus pollution. The number that kind of floats out there, and it really depends upon the particular area, but that cities on the whole are really only responsible for about 15% of all of the phosphorus pollution in the state. And the majority of that is coming from other sources. And the problem that we've seen with the riverine standards, the overarching standards are scientifically flawed. And MESRB and the CGMC has been actively challenging this. The agency has adopted two criteria within the standards that they use to determine whether or not a river is impaired because of phosphorus. And when the agency determines there is an impairment, then a city will get a limit, and that limit will then require wastewater infrastructure and further investment. And so the agency has used these two criteria: 5-day biochemical oxygen demand, or BOD5, and dissolved oxygen variation, or DO flux, when national experts in the field dispute what the agency is doing, and they say that it is simply scientifically unsound. The national expert, the method called the Standard Methods Organization, which is the expert on the BOD test, and the EPA has actually established this organization as the expert through federal regulation on the BOD test, published a memorandum saying that the way that the MPCA is using the BOD test is scientifically inaccurate, that this test cannot be used in a nutrient pollution or a phosphorus pollution framework the way that it's being used. And then the EPA itself, in response to some Freedom of Information Act requests, has said that it has no documents, no scientific support for the use of these criteria. And we've raised this to the agency, and their response has been, well, our scientists say it's fine. But the national experts on these tests say that it is improper. And that's the problem that we're dealing with in terms of the scientific flaws. And those are the type of scenarios when we need to push back. And then the other trend that we have seen, and I'll talk about this in the particular context of the river standards, is we have seen flawed analysis by the agency and data collection, and the data collection where they're really kind of cherry picking data to justify calculating more restrictive permit limits than necessary. We have seen fairly aggressive enforcement strategies where they will target a smaller city that they expect won't push back much, and then use the precedent from that city to apply it to other cities. And then the agency has also been amending standards, particularly in the river standards context, to allow for more restrictive calculations and limits through guidance documents rather than going through lawfully required rulemaking procedures, which is extremely problematic from our standpoint. And so the main example where I want to talk about some of the recent problems that we have seen, especially with the river eutrophication standards, comes out of the Minnesota River Basin. So if your city is located in the Minnesota River Basin, this is a time to perk up. We have done some extensive analysis and some scientific modeling in using the MPCA's own data and the calculations that the law requires to be used in the implementation of these standards, the mathematical equations that the law requires. The science demonstrates that you can remove all of the point source phosphorus pollution in the Minnesota River Basin, and that pollution is not, that reduction is not, will not have a statistically significant impact, positive impact on water quality. And so you can remove all of the phosphorus from cities in that river, in that Minnesota River Basin, and it will not benefit water quality. So it's clear in that context that wastewater is not the problem. And then the question becomes, why is the agency going in and requiring cities to upgrade and spend millions of dollars if it's not going to create benefits to the water quality? And the agency has realized this problem, we believe, and based on that realization, they are doing some perhaps some regulatory gamesmanship to impose the standard and to get more restrictive limits out of cities when the science shows that it's not necessary. And they're using old data that does not give cities credit for previous efforts and investments to reduce phosphorus pollution. So they're using data that does not incorporate the previous reductions of phosphorus that have been made from cities. And they're using they're kind of selecting mathematical equations to impose permit limits for phosphorus that are more restrictive and expensive than necessary. I think this is a really important example, and it's really important to pay attention to. We've seen this in the Minnesota River Basin and elsewhere. So the river standards require that when they're being implemented, that the agency use average conditions of the river. Instead, the MPCA is ignoring the law, and as they're applying these standards, they're using very rare low river flow conditions combined with very rare high flow conditions from wastewater treatment facilities. And what this does is it leads to a kind of an inflated condition, or it's manufacturing a condition where our scientific modeling demonstrates that it's almost impossible for that low river flow to coexist at the same time as that high wastewater treatment flow. And really our modeling demonstrates that it's like a 100-year event where that is possible. And that is the condition that the agency is using to calculate limits. And in the analysis that we have done, in many cases, that has led to a calculation of permit limits that are more restrictive by a factor of 6. So if the agency was doing this calculation using the average conditions as the law requires, limits would be much less restrictive or perhaps not necessary. And so this is a big problem from our perspective. And that use of these low flow characteristics and the high flow characteristics was not mentioned in the sonar, the development of the rule. All this is coming about through a guidance document that has not gone through rulemaking, which we believe is illegal, and it is going to cost cities money. And as a result of what we talked about, it's not going to benefit water quality, particularly in the Minnesota River Basin. And so the problem you see here is these costs are being imposed on cities as a result of these river standards, and hundreds of millions of dollars. Rates are going to increase. And the science demonstrates that there's no benefit to water quality. And so I think this is evidence that this clean water framework, particularly in this river eutrophication, the river standards context, is broken. And the tragic piece of this is it's going to cost hundreds of millions of limited dollars for clean water infrastructure. Greater Minnesota is going to get stuck with the bill, and our waters are going unprotected. And so the state has only limited resources for clean water infrastructure. Cities only have limited resources for clean water infrastructure. And so why is the agency requiring further upgrades when there won't be benefits to water quality? And I think this problem is encapsulated very well in a recent quote from a Supreme Court case from Justice Breyer, in which he says, and I quote, "In an age of limited resources available to deal with grave environmental problems, too much wasteful expenditure devoted to one problem may well mean considerably fewer resources available to deal effectively with other, perhaps more serious problems." And so this is the crux of the problem. If the agency is going to impose scientifically flawed regulations that impose limits that are more restrictive than necessary and extremely expensive, it wastes these limited resources where they could perhaps be allocated more effectively to actually benefit the environment. So when cities are pushing back against this stuff, they're not only benefiting themselves, they're also benefiting the environment. So the current problem overview, we've talked about it, and I really would like to move on to talking about the solution at this point. And when we're talking about the solution, we're really talking about kind of a proactive and enhanced municipal involvement. As Tim stated, the CGMC has been involved in these issues for some time. But what is now required, and the CGMC board recognizes this, is to enhance that participation similar to the way that the CGMC operated in the 90s and the early 2000s, and to really pursue enhanced legislative agenda, pursue litigation when necessary. And I think it's important to explain why cities can be so powerful in this conversation. It is clear from our past experience, and it makes sense that cities have a unique credibility on these issues with regulators, policymakers, and legislators, because cities are the ones on the ground floor doing what is often dirty work to clean and protect Minnesota's waters. They're the ones spending the money, putting time and energy into doing this work. And so when cities speak up on these issues, people listen. And so we have the ability, we don't necessarily have the same amount of funds as the commercial interests or the radical environmental groups, but we have the ability to punch above our weight in this area because of our unique credibility. And so the solution really is cities entering the fray to shape this policy in an enhanced way. And it's going to require a long-term commitment to a comprehensive and proactive strategy. That's this individual city approach and a collective approach. And those two approaches must operate simultaneously. I'm going to talk a little bit in more detail now about this individual approach, and then I'll go on to talk about the collective approach. The individual approach that we suggest that cities take is really, in some level, it's a change in perception. It's taking the long view when it comes to wastewater permitting, being proactive versus reactive. We really encourage cities to see this 5-year permitting cycle through a 30-year lens, because when you get a condition or a limit in your permit, it is permanent and it will govern your future economic development, social development, and population growth in significant ways. And so it's important to really think about how these permits are going to affect the cities. And then we really encourage cities to improve communication between the policymakers at the city and the technical city engineers and wastewater staff. The technical staff and the engineers are working with the agency on a day-to-day basis, and so it is often difficult for them to want to push back against the agency and rock the boat. And that's where it's the job of the policymakers, the city manager, the city councils, the mayors, to understand what is going on and to make some policy level decisions about, is what the agency asking reasonable? The cities have lots of other responsibilities. They have fire, police, roads, bridges, a host of responsibilities. And so it's the policymaker's job to get in there and decide, are these regulations and the costs that are going to be imposed and the benefits to water quality, are they reasonable? And as we talk about the individual approach, I'm just going to give a refresher about the general permit process. And so you got this 5-year permit cycle. And when a city's permit expires, they have to reapply and renew that permit. And the agency will then generally, and their policy is 2 weeks advance notice, get a review of the draft permit and fact sheet prior to the notice and public comment period. And the notice and public comment period is really what governs. It's this 30-day period. And in that 30-day period, the city has to make a decision whether or not they're going to accept that permit or they're going to fight it through a contested case petition. And frankly, we believe that 30 days for such an important decision that can really affect the long-term, has long-term implications for a city, is not enough time to really digest that information and make that decision. And if a city does not make a contested case petition or push back during that 30-day period, the permit then becomes final. And so what we recommend is that cities know and exercise their rights. It's important for cities to know that they have a legal right to challenge permit conditions. And we're going to talk a little bit about when to do that and when that is justified. It's also important for cities to recognize that they have a legal right to request the data and the analysis that the MPCA uses to justify limits in the permit. And we recommend cities get that information and perform an independent analysis of the data and the science, because what we have been seeing is that often the agency makes mistakes, and those mistakes can be very expensive for cities. But also, as we've talked about, there's some regulatory gamesmanship, some aggressive regulatory approaches that are probably not necessary in most situations, or at least in many situations. And so it's important for cities to double check what the agency is doing. This approach, we think, can kind of be encapsulated into call the 4 A's: anticipate, ask, analyze, and act. The anticipation stage is really that enhanced communication with technical staff, staying informed regarding regulatory and legislative changes that affect the city, Paying attention to what your current monitoring limits in your permit are, because if you're monitoring currently for chloride, there's a very good chance you're going to get a future limit for chloride. And then also communicate with other cities in your watershed so you understand what's going on. And then the ask component is we recommend that when a city's permit expires, you make a written request to the agency for 90 days prior to the public comment period. That they give you 90 days prior to the public comment period to review the draft permit, the fact sheet, the data, and the agency analysis so you can perform your own independent analysis. The analyze this is where you're doing that analysis. What are the short-term and long-term costs? How is the city going to pay for this? Is the permit reasonable? Is there a benefit to the environment? And then the other piece of this analysis that is very important is, are the standards scientifically legitimate? Is this permit, are the standards being applied correctly in this case? Is the data recent? Is it accurate? And is the math right? Are they doing sound and complete modeling? You have to ask all those questions. And if they're not doing that, we recommend that you file comments to the agency and that you inform them prior to that 30-day public comment period so you can initially push back and get some negotiation going with the agency. Request a response for them and a meeting if necessary. But you have to be prepared to act quickly, because once they publish the permit, you have 30 days to decide whether you accept it or not. And another point that I think is really important to make is that never accept informal or unwritten promises of leniency. We'll say, oh, if you accept this permit, well, we'll give you a variance down the line, or we'll give you a compliance schedule. Those things need to be negotiated in advance, and they must be in writing. And finally, if you have found significant scientific or legal flaws in the permit conditions that are in your permit, then we suggest that you consider filing a contested case petition. And contested case petition, as I said previously, must be filed within that 30-day notice and public comment period. And once it's filed, it goes to the agency, and the agency can either grant the petition, deny the petition, or do nothing. If they deny the petition, the city has the right to appeal it directly to the Court of Appeals. If they grant the petition, it goes to an administrative law judge. And then there are also rights to appeal depending upon what the administrative law judge says. The benefits of a contested case petition are really that it, first and foremost, it enhances a city's negotiation position. Cities are in a very difficult spot often, and this is the only thing that can really be done to enhance that negotiation position. And a lot of the outcomes that we see, I mean, most of these contested case petitions settle. They don't go all the way to a trial before the ALJ, or they don't go all the way to the Court of Appeals. A lot of the outcomes that we see is it is possible to eliminate unreasonable and unscientific limits and conditions. We can, in some cases, get less restrictive conditions if the evidence and the data warrants that. We can provide more time to comply with conditions so the city can do some planning about how to get this done. And we often find that the cost to file a contested case petition is often less than the money that the city would have to spend with immediately complying. And so the cost benefit analysis of the contested case petition generally works in the favor of the city, because it gives you more time and it gives you this pushback ability, and it can often save you money in the long run. And then finally, this also serves as a buffer. When you file a contested case petition, it serves as a buffer to protect other cities from MPCA overreach, because then they can't use you as that precedent to then go and try to force what they've done to you elsewhere. So to summarize this individual approach, again, we suggest that you anticipate, you stay informed, communicate with technical staff, that you ask, that you make a written request once your permit is expired or expiring for 90 days to review the draft permit and fact sheet prior to the public comment period, that you then get that information, get all the data, and then you perform the analysis. Is it reasonable? Is it scientifically sound? And if there are issues, that you make comments to the agency before the public comment period, that you initiate some negotiation. And if the agency is not willing to adjust its stance in a reasonable way, and it's going to stick to unscientific or unreasonable conditions, then we recommend that you file a contested case petition. So now I'd like to move on to the collective approach. And as we talked about, this individual approach is essential, and cities must and should do this, what we talked about. But alone, this individual approach isn't significant to impact meaningful systemic change to fix the broken system. It must be paired with collective action. As the graphics on the slide demonstrate, cities alone can get overwhelmed, but together, when they come together, they can make a significant and lasting impact. Some current examples of collective action are the CGMC and MESRB challenges to the river standards. We currently have a federal lawsuit pending challenging the EPA's approval of the scientifically flawed river standards. The scientific flaws that we talked to with those two criteria where the national scientists have said that they're scientifically flawed. We have a lawsuit in federal court about that. And we've also filed a state rulemaking petition and now an appeal of the decision in that petition to try to force the agency to fix these standards. And by filing these lawsuits, we have seen some positive results, but there is a long way to go to correct the standards. And those are examples of the type of collective action, because a city, if it's fighting unreasonable conditions in its individual permit alone, it's not going to likely change the law for other cities. The only real way to change the overarching standards and the framework is when cities come together to push back. And then the collective approach, generally speaking, and Tim is going to come back in a minute and talk about the CGMC's Environmental Action Fund and how it's going to implement this collective approach, but just some guiding principles. Cities have to be proactive rather than reactive and defensive. And as Tim said, we have to take a solution-oriented position where we're not just saying, don't pick on us, but we're also presenting solutions to the real pollution problems that exist. And we have to be committed to a long-term strategy. This isn't a one-year deal. We have to push back consistently. We have to improve communication and coordination among cities to ensure that we know what each other are doing and what the agency is doing. We have to pursue proactive and an enhanced legislative program, and we have to initiate and support litigation where it's necessary. And last but not least, we have to develop creative partnerships with businesses, environmentalists, local state government, and the MPCA to solve the problems that exist and figure out ways to efficiently and effectively address water quality problems. And now I think Tim is going to come back and talk about this Environmental Action Fund and what the CGMC is doing. Thank you.
Well, thank you, Daniel. I've heard that story before and actually lived it for 20 years. So I appreciate the presentation. The question is, where do we go from here? And I think the answer has come from the CGMC membership and the board of directors, which voted to establish an environmental action fund this year. I think that they recognize that if the problem, if it goes unchecked, it's going to have a very major detrimental impact on greater Minnesota cities. And the thing that, and I've experienced this firsthand, these assumptions that are kind of presented here. If the cities don't act, the problem will go unaddressed. And why do I say that? Why don't we just depend on somebody else to lead this effort to change the framework for the regulations and to make sure that the costs are jointly paid for with the state and the local units. It's because really these things really affect cities the most. It's not going to affect a lot of the metropolitan area to the degree, nearly to the degree it is going to affect the individual cities. So if we don't take this up, the biggest financial impact is on us. So if we don't pick this up, then I would say, who will? And the answer to that is nobody will. So we need to dig in and take this on if we're going to get any changes. Some people will say, well, just go sit down with the MPCA and they'll see that they're going in the wrong direction on some of these regulations. And I can tell you from about 30 years of experience that they will not do that. They will remain unaccountable for their scientific and regulatory decisions unless we take action. Now, this isn't specific to any particular governor or to any particular commissioner of the PCA. This behavior has been going on for years and years and years, and it's not going to change unless we get the legislature involved and kind of make these changes at that level. Legislature will continue to be divided on whether to limit the MPCA's overreaching regulations and whether and how much the state should pay for its water mandates. Like I said at the beginning, the governor stepped forward and proposed significant funding in his bonding bill to help cities pay for some of these new regulations, and that is very much appreciated. But it's going to take year after year of significant state funding, year after year of challenging unnecessary rules. So that's why we created the Environmental Action Fund. So the Action Fund really has several purposes. We're going to create an ongoing pool of resources for legal and regulatory efforts. It's like Daniel was talking about. We had to sue the EPA, we had to sue the state, we have to be involved in the regulatory process, and it all takes a lot of resources because we have to know what we're doing. We have to hire experts and have scientific knowledge and evaluation of modeling and other things, and this is not inexpensive, but it's necessary. We're going to assist individual cities, so that small cities with a big problem don't get set a precedent that all other cities have to face. We're going to enhance our legislative advocacy and be very proactive in that. And one of the things that I think the board wisely decided was that it's not enough to be right or to offer solutions. It's important that we explain to the media what we're doing and why we're doing it, so that we don't get blamed as just bad polluters. So what we've done then is to set up a voluntary assessment to raise $150,000 for our Environmental Action Fund. That boils down to 35 cents per capita per city. I do want to mention that every city in the coalition will contribute something to this environmental effort by the 5% increase in surcharge in the dues for this year. So combined from these two sources, we hope to have enough, I think we will have enough to pursue the litigation, the rulemaking, and the legislative efforts that are going to be needed. So with that, I will ask Daniel to come back and we will take questions. So what questions have we had come in so far?
So at this point, it doesn't seem that we've gotten questions through the email. And we would like to make it clear that this presentation is going to be online for people to view after today. And if there's no other questions, Tim, is there anything else that you think we should touch on?
Well, not really. I think that you can go to CGMC. What is that? That is CGMC_communications at flaherty-hood.com. If something comes to you, if you want some advice, give us a call or send us an email. We'll be happy to help. But I think the takeaway from this thing is we need cities to be involved both at an individual level and at the coalition, the joint level, to really fix this big problem. So I guess that's all I would have to say. And like I said, thanks for participating. Thanks for joining us and listening to this broad presentation on environmental regulations.
Thank you.